Hi everyone, great to see so many people join us online. Welcome to this Mathys Squire webinar on Supplementary Protection Certificates in Europe, Part 2, which will be presented by Peter Arch and Alex Robinson, attorneys at Mathys Squire. This session is a follow-up from last week's webinar that provided the foundations. My name is Sabah Ismail, BD exec at the firm, and I'm delighted to be your host today again. So without further ado, it's my great pleasure to introduce our presenters, Alex Robinson, UK and European patent attorney. He handles matters in the chemical sciences with a focus on small molecule pharmaceuticals. His work includes prosecution of patent and SPC applications, as well as contentious proceedings at the EPO. Our second presenter is Peter Arch, UK and European patent attorney with extensive experience at drafting and prosecuting applications for pharmaceutical and chemical technologies, and represented multinational companies at numerous EPO hearings. So without further ado, I'll pass over to the presenters.
Thank you, Sabah. Welcome everyone, and welcome back to those people who joined us last week as well for the first of this two-parter on SPCs. I'll jump straight in because I know that last week we ran out of time in terms of questions, so I will jump straight in now, and hopefully we'll have a bit of time to answer any questions at the end. So in this webinar, we'll be looking at two main topics that have been particularly controversial in recent years. The first of these is secondary SPCs, which most recently came up in last month's CJEU decision in the Suntan case. And then we'll go on to look at what we've called the saga of Article 3A. So that's all about the requirements for the product for the SPC to be protected by a patent. And it's turned out to be particularly surprisingly hard to work out what the word protected means in that context. And this issue most recently came up in the royalty Pharma CJEU case in April this year. So all of the cases we're looking at the moment in this webinar are CJEU cases, CJEU case law, because it concerns the interpretation of EU legislation. But of course, underlying any CJEU decision, there's always a national case, a national referral. So if anyone is interested in the details of those or wants to know how the CJEU decisions have been implemented, especially in the UK, particularly in the UK, because a lot of these cases derive from UK referrals, please feel free to drop us an email, and we'd be happy to answer any questions you have on that. And so I will now pass over to my colleague Alex to kick us off on secondary SPCs.
Thanks, Peter. So as he said, we're going to be starting with what we've called secondary SPCs. As you know, to get an SPC for a product, you need a marketing authorization covering that product. And all we mean by secondary SPC in this talk is an SPC that's based on a new marketing authorization for an active ingredient, an old active that's been previously authorized. Often that active will also be the subject of an earlier SPC. So the new authorization could be for a new formulation of an old active, or it could be for a new medical indication, such as a change from veterinary to human use, or a change from treatment of one medical condition in humans to another, or a change in dosage regimen or mode of administration or patient group. That's what we're talking about.
So the wording of the SPC regulation really suggests that secondary SPC shouldn't be allowed. And the reason for that is both of Articles 3C and 3D. So 3C says that one requirement for getting an SPC is that the product has not already been subject of a certificate. And Article 3D requires that the authorization that you're relying on is the first authorization to place the product on the market as a medicinal product. But as we touched on last week, often perhaps, the wording of the SPC regulation doesn't actually mean what it says. So for example here, Article 3C, we saw last week, doesn't actually mean that only one certificate can be granted for a product, because we know that different patent holders can get certificates for the same product. So key question for this is what is the product for the purposes of Article 3C and Article 3D? Is it just the active ingredient, or does it take into account other aspects such as the scope of the authorization, the scope of the basic patent, the formulation? Is the formulation relevant? Is the authorization, the authorized indication relevant?
So the early case law suggested that the term product was construed very narrowly, was it related only to the active ingredient. So the form of presentation, the medical indication, the formulation, all those kinds of characteristics were irrelevant. If you've already had an authorization for the active in any form for any purpose, you couldn't then get an SPC based on a later authorization for a different presentation or a different indication. And this all changed in 2012 with the CJEU decision. So to recap that very quickly, the SPC application here was based on an authorization for the use of melatonin in treating human sleep disorders. There was an earlier authorization for the same active ingredient, melatonin, but that had been for use in managing fertility treatments in sheep. So on that basis, the UK Patent Office, taking quite a narrow approach, refused the application, but this was appealed and found its way to the CJEU, and they decided instead that the earlier authorization, the one for treatment of fertility problems in sheep, didn't necessarily prevent the grant of an SPC based on the later human authorization. And the court said that it was relevant to consider the relationship between what was authorized and what the scope of the protection conferred by the basic patent was, the patent that was being relied on for the SPC. Now, in this case, the older authorization, the one for use in sheep, didn't fall within the scope of the claim in the patent that was specifically directed to the use in this new medical indication in humans. So that seemed to overturn the earlier case law, but what wasn't clear was how widely this decision could then be applied. You know, how did that logic extend to other situations like the ones I set out a couple of slides back, where you had maybe a different formulation or a change from one human condition to another, and different countries took different approaches to this. So in a way, it was inevitable that we get more questions referred to the European Court.
And one of those cases is Abraxas. So this, well, there was always a tension, I think, between Neurim, which said that the authorization that you're talking about as the first authorization is the first one that falls within the scope of the claims of the patent, and the earlier case law, which Alex touched on, which said that actually the term product shouldn't take into account the use. And the first real hint, really, that the Neurim case law might be rolled back came in this Abraxas case last year. And the situation here was that the UK Patent Office had refused to grant an SPC in respect of nanoparticles of albumin-bound paclitaxel, because there was already an earlier authorization of paclitaxel itself, of the drug itself. An important aspect here is that the UK court found that the product here was paclitaxel. The active substance was paclitaxel, and so the albumin-bound nanoparticles were considered essentially to be a new formulation of a previously authorized product. So the question really was, does Neurim apply to new formulations? And this question went to the CJEU and essentially was the answer was straightforward, that new formulations of old actives were not eligible for SPC protection if the active had already been authorised previously. So even though in this case the new formulation was said to improve efficacy of the drug, it didn't qualify for an SPC. Unfortunately, the answer in this case didn't really give us a kind of wider answer as to the extent of the Neurim decision and how applicable it was to other cases other than the specific factual circumstances in this case. So the decision referred to Neurim as an exception to the rule that the product just means the active substance, but it didn't address the broader issues about how Neurim should be applied. So it was really inevitable that this issue would come up again in a subsequent decision, and we saw that in Suntan earlier this year.
So in the Suntan case, that was actually, I think, referred to the CJEU while Abraxas was still ongoing. And so we didn't have to wait long after the Abraxas decision before we got a decision in Suntan as well. Now here we had an SPC application which was for this product, Ecurvis, which was based on an authorization for cyclosporin in the form of an eye drop emulsion for treating keratitis, that's inflammation of the cornea. Now, the French Patent Office had refused the application for the SPC as there was an earlier marketing authorization for cyclosporin, this time in an oral formulation for treating a number of conditions, including uveitis, which is inflammation of the middle layer of the eye. Now, the French Patent Office also noticed that the patent, the basic patent here, was directed to the formulation as such and not to the keratitis indication. So even on the on a fairly narrow reading of the earlier Neurim decision, there was a question here about how the scope of the authorization and the scope of the patent related to one another. Remember that Neurim has suggested that the medical indication in the patent claims could be a relevant consideration, and that just wasn't there in this case. There was another interesting aspect of this case, which was that there was a dependent claim which actually did recite uveitis, which was the same indication in the earlier formulation. So once again, this went up to the CJEU.
And the questions referred by the French Patent Office were quite lengthy, so they're not shown here, but they were aimed at clarifying the Neurim decision with respect to Article 3D of the regulation and how broadly that should be interpreted. So in particular, they asked whether the different application justifying a later SPC was limited only to the facts of Neurim, i.e. a veterinary use versus a human use, or whether it could be applied to any new therapeutic application, such as to different human therapeutic applications, or a new formulation in which the active ingredient acted differently from how it did in the previously authorized product. They also asked about the relevance of the patent claims, and in particular whether they needed to be restricted to the same therapeutic indication as the new marketing authorization in order for an SPC to be allowed. And as Alex just mentioned, obviously in this case, the claims were not limited in that way.
So here's what the CJEU said. It's quite lengthy, but in essence, they, rather than clarifying Neurim, putting a few more sort of details to fill in the circumstances where Neurim could and couldn't be applied, instead the CJEU took a very unusual, I think possibly unprecedented approach, and pretty much overruled their earlier decision. They stated simply that new marketing authorizations directed to new therapeutic applications of a previously authorised active cannot be considered the first marketing authorisation at all. There's no SPC. There don't seem to be any other conditions or nuances here that would allow you to reconcile Neurim with the other case law. It seems to essentially wash Neurim away as if it had never existed. I'm just moving on to the next slide for Peter.
Thanks, Alex. Yes, as Alex said, I mean, the upshot here is that the Suntan decision it appears at least to overrule Neurim entirely. And if you look at the detailed reasoning in the Suntan decision, the CJEU essentially does say that Neurim was wrong and that there's no legal basis for reading anything into the meaning of the term product in the regulation other than that it means the active ingredient. So the scope of the basic patent is essentially irrelevant. Indeed, the decision specifically states that contrary to Neurim, you do not take into account the limits of protection of the basic patent. So this does seem to spell the end for secondary SPCs. And there's also, of course, a question as to whether previously granted SPCs under the Neurim approach are still valid. That obviously wasn't dealt with directly in the Suntan decision, but there is obviously a big question mark now over such SPCs. Just considering possibly kind of possible rays of light here, whether there's any hope to cling on to. And one consideration is maybe that if you have a salt or something like that with a distinct therapeutic activity, something where the product is a little bit different and it results in different therapeutic activity, perhaps you could get a kind of secondary SPC for that still. But then essentially your argument would be that it's a different product. So your argument would be that it essentially isn't a secondary SPC, it's an SPC for a new product. But that's just our speculation, and fundamentally it is quite difficult to see a way around Suntan for secondary SPCs. So great news for generics manufacturers, but obviously not such great news for innovator companies.
So that was a quick run through the latest case law on secondary SPCs, and we'll now move on to part 2 of this talk. And the question here is really, well, what does Article 3A of the regulation that you can see on the left there mean when it says that the product is protected, the product should be protected by a basic patent in order to qualify for an SPC? Now, this is a very long and complicated story. We've only got time to look at this briefly today. So if anyone does have any questions, we'd be happy to fill you in on a bit more detail later. But the basic issue here is that the case law has just struggled to define what's meant by this. What is clear now is that an infringement test isn't the appropriate test. That is, just because the product would, in principle, infringe the claims if it had been made by someone other than the patent holder, that doesn't mean that it's protected for the purposes of the SPC regulation. Instead, the product needs to relate in some way to what's claimed when that's construed properly. It needs to relate to what terms in the claims say. But even that isn't enough. The case law seems to say that something more is needed. And where the courts have really struggled is how to pin down what that something more is, despite there being more CJEU cases on this single point than on any other under the SPC regulation.
So looking at the case law, I mean, the difficulty really begins with the Mediva case, which said, as you can see on the top bullet points here, that the active needs to be specified in the wording of the claims of the basic patent. Now, those of you who joined us last time will recall, or may recall, that this is the case relating to combination products, and in that case, SPCs were only considered allowable for a combination where that combination was specified in the claims of the basic patent. Several other decisions followed on from Medeva, which used the term identified in the wording of the claims, but there was no kind of hint as to the degree of, how those products needed to be identified and the degree of specificity. Then in the Eli Lilly case, the third bullet point here, a situation arose where the product was defined in functional terms rather than structural terms. It was an antibody defined as binding to a particular target, as is fairly common with antibody claims. And in cases like this, it can be difficult or even impossible to identify the product specifically in the sense of giving an individualized, precise structural disclosure. And in this case, the CJEU clarified that actually that isn't necessary to meet the kind of specified or identified test. And what they said was that it was enough that if the claims relate implicitly but necessarily and specifically to the active ingredient. So I will gladly hand back to Alex now to explain to everyone what that means.
Thanks, Peter. So, like me, you're probably wondering, this is certainly my reaction when I first read that case, what on earth that's supposed to mean. How can a claim relate both implicitly and specifically to a product? What does the word necessarily add to that? And fundamentally, how does a claim relate to a product? Well, you wouldn't be alone. Robin Jacob, who will be familiar to many of you as a now retired, very eminent IP judge from the English Court of Appeal, famously described this test as being close to gibberish, and pretty much accused the CJEU of failing to understand what how patents worked. And while that's quite harsh, I think to some extent he might have a point. If you look at the detail of CJEU judgments, they do tend to use terminology from patent law in contexts that aren't quite what we would normally think that terminology means, or they seem to sometimes show a slight inability to grasp differences between what's meant by a specification in a patent versus a regulatory document, for example. And this comes from the fact that most of the judges at the CJEU aren't actually trained, they don't have a background in patent law. So I think that's where some of the difficulties arise. And often the answers are quite sort of academic, they're quite policy-based and aren't really very easy to implement in practical terms. But that's the test. And the CJEU, for its part, essentially washed its hands of the matter of how that should be implemented and said, well, this has to be decided by national courts because how you construe claims, that's a matter for national law and for the European Patent Convention. It's not a matter of EU law. But what seems to emerge from this is that, as I said earlier, we've got a spectrum here of individualization of the particular structure of the active at one end, which, while that can certainly suffice, isn't necessary. And at the other end, you've got an infringement test where the fact that the product would infringe the claim, notionally, that isn't enough either. So the answer lies somewhere in the middle as to what degree of disclosure is required. Now, in the UK, at least, the courts here began to advocate what they called a so-called core inventive advance test. That is, does the authorized product somehow embody the same technical contribution that's represented by the patent, and that is somehow reflected maybe in the data in the patent itself, or in the problem that the patent explains that it sets out to solve. Now, this was an approach that seemed previously to have been suggested perhaps by the European Court itself in the Actavis case that I cited at the bottom there, but that formally related to Article 3C, considering what the product was in the sense of whether it had been subject of an earlier certificate or not. So that was a separate question from determining what the patent protected, and it wasn't entirely clear whether or not this applied to the question of Article 3A. Back to Peter.
Yes, and if you find all of that quite confusing, then don't worry. So did the UK courts, who eventually essentially sent the issue back to the CJEU in Teva v. Gilead, which is discussed on this slide. So here, the SPC related to a combination of two actives. Those were tenofovir disoproxil and emtricitabine, which is almost impronounceable, but I just about managed it there. Now, the first of those actives, TD, undoubtedly fell within the scope of a formula in the claims, and it was actually singled out in one of the dependent claims, 27. But the second wasn't mentioned in the patent except by generic language, which referred to just very generically other therapeutic ingredients. And the court had a question as to whether this was specified implicitly but necessarily. Was that specific enough to meet the CJEU's test? The court could decide. So the question that it asked the CJEU was a very simple question, I guess, just an attempt to get a general answer from the CJEU on this point, which could be applicable in other cases as well. They asked what are the criteria for deciding whether a product is protected by a patent. And Alex will discuss the answer for us.
Thanks, Peter. So in reply to that question, the CJEU came up with this two-prong test, which you can see on the slide here. Unfortunately, this seemed to take one unclear test, the implicitly but necessarily and specifically test, and replace it with another. I think the court actually took the view that this was just an illustration of how to apply the earlier test, but nevertheless, I'm not sure it sheds much more light on this. There are a number of questions that arise from here. So, for example, what is meant by fall under the invention in part one of the test, for example? Is that the same concept as a so-called core inventive advance test that was advanced by the UK courts, or did it mean something subtly different? In the reasoning behind this, the CJEU referred to the need for the product to comply with the technical specifications of the invention as set out in the patent, and for the product to be, and I quote, a specification required for the solution of the technical problem of the patent. Now, to me, that doesn't really clarify matters. How can a product be a specification? What were they getting at by that? And then in part two of the test, what do they mean by specifically identifiable? Fundamentally, that's still not answering the question of how specific does your disclosure need to be. And it's again hard to see how that should be applied, particularly in the case of functional claims, such as antibody claims, rather than structural claims. And so this really does leave a number of questions no clearer than before, in my view.
And talking of functional claims, on to the most recent case on this matter, which is the royalty Pharma case. And this related to a functionally defined small molecule. So the patent was directed to DP4 inhibitors for the treatment of diabetes. So the functional definition there is that they are inhibitors of DP4, but actually the product sitagliptin, which the authorization related to, wasn't disclosed in individualized form in the patent. even though it did fall within the scope of that functional definition. So the SPC had been refused by the German Patent Office and others, actually, on the basis of Article 3A, saying that the product wasn't protected in a sufficiently specific manner, but the SPC was allowed, it was granted in other countries, and we have a list there on the slide showing which of them.
So the German Federal Patent Court ended up referring 3 questions to the European Court, and we can see those 3 here in an informal translation from the German. Now, the first 2 of these questions ask again, in essence, how specifically a product needs to be identified in the claims or in the description, alternatively, if they're not identified in the claims, in order to be deemed protected by the patent. And I think what we can see here is that the Federal Patent Court was very much prompting the CJEU to address the question of, is individualized disclosure necessary, or is some degree of abstraction from that still permissible? The third question is quite an interesting one and came rather out of nowhere as far as I can see. And as you recall from the previous slides, the active here had actually been developed by a licensee at a date later than the filing date of the patent. So the patents had been filed at a very early stage of research, and then later on, presumably in a early stage trials or compound screening or something like that, the eventual lead compound had been identified, which fell within the scope of those claims. And the German court asked the European court to clarify whether or not in situations such as that, an SPC could be granted, notwithstanding the fact that the active fell within the scope of the broad claim. Now, my best guess as to why the court asked this is because there had been some hints in some earlier decisions from the CJEU, and in fact, I think this question had previously been asked in different terms but not answered in some earlier decisions, which was about the policy considerations behind the SPCU system and how that was set up to incentivize and reward the research underlying the patent. And I think the German Federal Patent Court here was probably trying to ask the CJEU to formalize that. As you'll see, they invented this term of what they called an independent inventive step, which turned out to be quite significant, but I'll let Peter talk about that.
Yeah, so here are the answers which the CJEU provided. I'll go over them in turn. Point 1, it essentially reiterates the tether test. So it talks about in order to be protected by the basic patent, the product has to necessarily come within the scope of the invention, and then it talks about the products being specifically identifiable. So I don't think that really provides a great deal of additional clarity over and above the tether test, but it is helpful. The decision was helpful in at least 1 or 2 respects, in that there was clarification that the tether test was applicable to structural and both structural and functional definitions, and importantly that it's applicable to both mono products and combinations. So if you recall from a few slides earlier, the tether case was related to a combination. This case related to a mono product, and essentially the same test applies to both. Another point to note is that in the reasoning behind its conclusion on the point 1, the CJEU did finally confirm that the core inventive advance test, which the UK courts had been advocating repeatedly and desperately trying to get the CJEU to agree to, was not a relevant test. So that approach, based on the core inventive, whether the product embodies the core inventive advance patent, that test was rejected. point 2 of the CJEU's answer is probably the most worrying point here for innovator companies. So it says that a product is not protected in the sense of Article 3A by a basic patent, even if it's covered by a functional definition, if it was developed after the filing date for the application for the basic patent following an independent inventive step. So, of course, in many cases, there will be a basic patent which contains a broad functional definition, or such as in this case, or indeed a kind of Marcus structure which covers a lead compound, but actually that lead compound which goes on to be developed into an authorised product only comes along, is only identified specifically after the filing date of the patent. So that is obviously a concern here in respect of point 2. But it's not quite clear here to what extent the research needs to have progressed on from the basic patent in order for this kind of independent inventive step to be fulfilled in reaching that actual kind of authorised product, and how is that independent inventive step judged against what prior art, what's the relevant date? All of this is quite unclear. So it's quite a, I mean, this decision has provided some clarity, but obviously there are still many questions to be answered.
Yeah, so overall, as we've just seen, while Teva and Royalty Pharma do provide some clarity, not least that individualized disclosure isn't required, that you can have some degree of generality in your definition of the product in the patent, there are a whole host of new questions here, some of which I start out here. The first of which is this requirement that the product should be identifiable by the skilled person in light of the information in the patent at the filing or priority date. Now, in the reasoning behind that, the court actually employed the language directly and unambiguously identifiable, and that seems to be a very conscious and, I think, deliberate echo of the language that's used by the European Patent Office when assessing added matter, new matter. And as we know, that's applied very strictly by the EPO. And in practice, to meet that, you typically require quite a high level of disclosure. So is the CJEU pointing at that being an appropriate test for disclosure of the patent in the sense of Article 3A? The other interesting thing that comes out of both of those cases for me is that in both Teva and Gilead and in Royalty Pharma, the court seemed to emphasize the importance of the prior art in making this assessment of disclosure. But it's not clear to me which prior art that should be, or indeed how the prior art is relevant to understanding what the patent discloses. In fact, there seems to be some suggestions in the reasoning of both decisions that it seems to suggest that the court might actually think that the terms common general knowledge and prior art are interchangeable and mean the same thing. And in fact, you'll see a slight difference in the wording of the Teva test and the condensed version of that 2-point test that's set out in the Royalty Pharma decision, where there's a very slight difference in wording, which again feeds this impression that there's a bit of confusion on the part of the judges here between those two concepts, and it's not clear to me how that's to be resolved. And then fundamentally, given that the core inventive advance test has now been officially ruled out, how are we supposed to assess whether the product falls under the invention or comes within the scope of the invention, to use the two phrases employed in those two different decisions? To me, conceptually, that seems to be a similar sort of test. So how do you reconcile that if the core inventive advance is not something that you take into account? Now, the court's reasoning seems to suggest that the judges think that assessing what the inventive advance is, or rather the subject of the invention, is something to do with Article 69 EPC. That's suggested by their references to the technical specifications of the invention, for example. But that suggestion would baffle most European patent attorneys, I think, myself included, because Article 69 is all about assessing the scope of protection. And we've also been told that an infringement test isn't the right test. So there are a few strands of thought in there that I have some difficulty resolving. And finally, what's meant by developed and what's meant by independent inventive step. Peter already went over some of the issues there, but to give a few examples, how do we define what's meant by product being developed? Is a mere paper example of the structure enough that it's been conceptualized in somebody's mind? Does the product need to have been synthesized or isolated? Does it need to be undergoing clinical trials? Does it need to have been isolated in drug screening, perhaps as a result of an AI program? What if a product is presented as a paper example in the patent itself, but then you don't actually really know until after the filing date whether or not it does indeed achieve the same advantage as the other compounds in the patent. So all of these are the types of questions that we now need to ask ourselves, and unfortunately I'm not quite sure what the right standard is for assessing those.
So just to finish, a brief summary of what we don't know, what we do know, and what we can do about it practically. So the first point here is that we do at least have clarity that an individualized disclosure is not necessary in all cases to comply with Article 3A. But we still don't know what the permissible degree of generalization is in order for a product to still be considered protected. So in view of this, in terms of practical advice, the safest option certainly seems to be, if possible, to opt for a patent having the narrowest disclosure as the basis for your SPC. So if you have a choice and other factors aside, and one of your patents specifically mentions your product and the other one has a more generic definition, then the safest option is to go for the one where it's specifically disclosed. And I mean, this can be borne in mind as well when drafting specifications. So obviously, if you're thinking about SPCs, then you want to include in your application specific examples of the compounds which you might want to rely on, which you might want to protect with an SPC later. Applications undergoing prosecution, obviously it's preferable if you can include claims, even as dependent claims, which are narrowly drafted around the product or the combination which you might want to get an SPC for. And even for granted patents, there's potentially a possibility to kind of go back and make things better with a post-grant amendment. One warning there, as you can see on the slide, is that the Advocate General in the Teva case seems to kind of disapprove of this approach, essentially as being a bit artificial, but that wasn't incorporated into the CJEU's final decision on the matter. So that's still something to consider. Okay, I think we're running to the end of our time now, and I can't see any further questions. So perhaps Saba, I can hand back to you to wrap things up.
Yeah, thanks so much, Peter and Alex, for your informative presentation. I'd just like to take the opportunity to say a huge thank you for everyone that's joined us today, and hope you found the session useful. I would like to mention that you will be redirected to a feedback form. We really love to hear your thoughts about future webinars and how we could improve. And lastly, just to mention that on the next slide, you should see Peter and Alex's email addresses. Please feel free to get in contact with them, and if you feel like you want to discuss anything that was mentioned today. And just to really finally say, we hope to see you at one of our future webinars. Thank you and take care. Thanks, everyone. Bye.